Good afternoon and welcome to another Alliance for Health Policy webinar. I will say at the outset, happy Juneteenth National Independence Day. We wanted to bring you this webinar right off the heels of the Supreme Court ruling on the ACA. I should say the latest ACA ruling on the ACA. It is another June. The cicadas seem to have disappeared in Washington, we think, and there's another court ruling to parse over. So thanks for joining us today. I'm Sarah Dash, President and CEO of the Alliance. And for those of you who don't know us, we are a nonpartisan nonprofit dedicated to advancing knowledge and understanding of health policy issues. The Alliance for Health Policy gratefully acknowledges the National Institute for Healthcare Management Foundation for supporting today's webinar. I'm going to review some very quick housekeeping items. First, I want to remind everyone that you can join us on Twitter using the hashtag AllHealthLive and join our community at AllHealthPolicy, as well as checking us out on Facebook and LinkedIn. We want you to all be active participants, so get your questions ready. You should see a dashboard on the right-hand side of your web browser. There's a speech bubble icon with a question mark. You can use that to ask any questions you have, or if you have any tech issues, feel free to send those in. And finally, be sure to check out our website, allhealthpolicy.org, where you can find background materials, including a resource list and an expert list, and a recording of today's webinar, as well as any background resources will be made available there soon. So the Affordable Care Act is a landmark health policy package signed into law in March 2010. It has faced no shortage of political controversy and legal challenges over its 11-year history. One such case, Texas v. California, began when the Tax Cuts and Jobs Act of 2017 effectively eliminated the individual mandate provision. It's since worked its way through United States District Court, Court of Appeals, and now the Supreme Court. And today, I'm so pleased to be joined by an esteemed group of experts to help us understand what happened yesterday and what are the potential future implications, not only in the legal sphere, but for healthcare coverage and affordability writ large. First, we will have joining us Katie Keith. She is principal at Keith Policy Solutions, LLC, and an adjunct professor at the Georgetown University Law Center, where she teaches courses on the Affordable Care Act and LGBT health law and policy. Katie is also an appointed consumer representative at the National Association of Insurance Commissioners, where she represents the interests of consumers in front of state insurance regulators from all 50 states. Next, we will be joined by Elizabeth Carpenter, who is head of advisory services at Avalier, where she specializes in the implementation of the ACA. Prior to joining Avalier, Elizabeth was a senior advisor in the health policy practice at McKenna, Long & Aldridge LLP, where she provided government affairs and public policy support to payers, providers, private exchanges, and states on a wide range of health policy and political issues, and previously had a career on Capitol Hill. And finally, we'll be joined by Thomas Barker, who is a partner at Foley Hoag and co-chair of the firm's healthcare practice group. Prior to joining the firm, Mr. Barker served in a series of senior level positions at the Centers for Medicare and Medicaid Services, CMS, at the U.S. Department of Health and Human Services during the administration of President George W. Bush, including as General Counsel of CMS, Counselor to the Secretary of HHS, and General Counsel of HHS. And so we are going to launch today's discussion by hearing from Katie Keith. Katie will provide past, present, and future legal timeline of this case and maybe give us a little insight into what's next. Katie.
Hi, Sarah. Thank you so much. Thank you for having this. I feel like this group of 3 experts has been able to do this multiple times. I feel like every year we get together and talk about this case. So
we have to stop meeting this way.
So here we are. So thank you for the opportunity. I think, what the Alliance has been doing on this case has been incredibly helpful to really explain it to certainly folks on the Hill, but also federal and state officials and the media and other stakeholders. So thank you. It's a great opportunity. Just to even build on what Sarah was saying, this lawsuit in the very brief history really stems from the changes in the Tax Cuts and Jobs Act in December 2017. And then this lawsuit was filed by a coalition of Republican attorneys general led by Texas and 2 individuals in Texas in February of 2018. So it's been more than 3 years that we've been holding our breath in terms of what the Supreme Court would do, and we have clarity as of yesterday. So the big news here is that in a 7-2 decision, the Supreme Court fully dismissed this legal challenge, California versus Texas. They did so on what we call standing, and I will give some highlights of that, but for folks who are very interested or want to get in the weeds on standing, happy to do that during the Q&A, or I did a longer post for Health Affairs that you can read up on your heart's desire on standing. But 7-2 decision, vast majority of the court, I think a resounding decision, really saying that this group of state plaintiffs, again led by Texas, and the 2 individuals in Texas are not injured, and even if they were injured, the entire individual mandate is what we call unenforceable. Essentially, it means there's no reason this case should have been in court. Standing is a constitutional requirement. Really, we're not supposed to use the federal courts to be issuing advisory opinions, or you're not supposed to have anybody can come to court and sue over something they don't like. The courts under Article 3 are really there to resolve genuine cases or controversies, meaning there has to be a real dispute between the parties. That matters here because anyone who comes to court and sues has to have an injury, it has to be fairly traceable to the person that you're suing, and it has to be actually redressable by the court. And so here the Supreme Court was kind of focused on that test that I just laid out. They didn't quite grapple with whether the penaltyless mandate imposes an injury, but they did say that it was not traceable to anything based on that the federal government was doing. And even a decision here to strike down the mandate wouldn't actually redress the injuries that the 2 individuals in the states were saying. They essentially said this penaltyless mandate is unenforceable. The government can't take any action against you if you don't comply with it. Even if we were to strike down the mandate, Justice Breyer wrote, nothing would happen. And so this would essentially amount to an advisory opinion, which is not what the federal court system is supposed to be used for. One of my favorite quotes from the decision is Justice Breyer wrote, "There's no one and nothing to enjoin. There's no behavior to stop here. This case, in many ways shouldn't have made it this far." And so one thing I guess for this audience too, that the lack of enforceability here really cut against both the individual plaintiffs and the state plaintiffs, but Justice Breyer and the court also took on the sort of lack of evidence for the state plaintiffs. Texas and others had argued they're harmed by the penaltyless mandate because more people will still want to comply with the mandate and will enroll in public coverage programs. So maybe Medicaid or the state employee health plan, that will lead to higher costs for Texas. The court said maybe that would be a possibility, but they really agreed with California and the House, who were defending the ACA here, to say it wasn't enough proof. And I think especially for this audience, one key piece of this, Texas had really pointed to a 2017 report from the Congressional Budget Office that had estimated that about 4 million people would continue to enroll in coverage even without the penalty. The court here said that by itself is not enough. And I know I personally had concerns that if one CBO report was enough to give standing for this type of lawsuit, it really would have opened the door and the floodgates to many more types of this type of litigation. So I think a good thing there, but Texas could have had standing, they just didn't prove it. They didn't give enough evidence to show that actually having no penalty is going to lead folks to enroll in greater numbers in Medicaid and state employee health plans. The court really recognized that there are other reasons why people would want to enroll in those programs and other benefits that are completely unrelated to the mandate itself. One last thing I want to say in terms of the actual decision is the court did reject what experts have been referring to as the standing through inseverability theory. And this is the idea that even if I'm not harmed from the individual mandate itself, I'm harmed from other parts of the Affordable Care Act. The individuals had argued that they were harmed by, the insurance market reforms, having to buy a plan that covers essential health benefits drives up premiums, and I don't like that. The states had pointed to Medicaid expansion and the employer mandate and all these other things that they believe harm them as standing. And they said, those provisions are inseverable in their view from the mandate. That should be enough to show the harm and show that we have standing to come to court, challenge the individual mandate, and have those other parts of the law struck down. The court really rejected that theory, particularly for the state plaintiffs, but I think it should apply to the individual plaintiffs as well. So I think, especially as this audience thinks about, the next wave of congressional reforms and how much we do in omnibus legislation these days, that theory would have been, I think, very challenging if accepted by the court, and they did seem to reject it here. The takeaway being you have to be harmed by the provision of the law that you're challenging in court. If you're not harmed by the mandate, there's no reason for you to be citing these other things. So from here, what happens next? The court was very clear. It directed the district court, Judge Reed O'Connor, to dismiss the lawsuit. So this challenge is certainly on ice. I would like to think it will not come back. You know, the very small caveat there is Justice Alito, who dissented. He was joined by Justice Gorsuch. He practically invites this challenge to be refiled or other litigants to come forward. He really embraced that standing through and severability theory. So, you know, I never say never on ACA litigation, but I would like to think that such a resounding victory, 7-2, even with a much more conservative Supreme Court than the prior two challenges that we've seen, I think it's a clear indication that plaintiffs who are expecting the Supreme Court to come in and make broad changes to the Affordable Care Act should not waste their time on doing that. I think they've made very clear after, you know, 3 major challenges in less than a decade that they do not have the appetite to make the broad changes that ACA opponents in particular might want them to make. So that I will maybe stop there on the court. You know, even though I don't think we'll see maybe necessarily the same types of big legal existential challenges in court, there's a ton of ACA litigation out there that continues, and we could sort of get into that. One thing I did at least want to flag up top is that even yesterday, the court was scheduled for a conference on whether it should hear insurance companies' appeals over a case for unpaid cost sharing reduction payments. So we could learn if they'll take that case for next term as soon as Monday. So on the day that they're issuing California versus Texas, they're considering perhaps their next ACA appeal. So I look forward to the questions. I hope that was not too much on standing, but thank you for having me.
Thank you so much, Katie. No, that's great. And it's because, you know, I can't help it because we've been surrounded by these cicadas. I'm like, are they really gone? Or am I going to step on one like again? So no, it's very interesting to hear your forward-thinking analysis, and thank you for that great overview. And we'll have lots of questions. I want to remind the audience, if you do have questions, just feel free to put them in the chat at any time, and we will do our best to address them during the broadcast. So now I'm going to turn it over to Elizabeth Carpenter, who will discuss potential implications of the ruling for consumers and key industry stakeholders. Hi, Elizabeth. Thanks for joining us.
Thanks for having me, and thanks for all the cicada talk, right? All of us with little kids, I feel like have been living the cicadas.
Yes.
And Katie, thanks for covering sort of the complexities associated with the case. And, you know, I personally am really interested to see, I do wonder if the Affordable Care Act is one of these sort of domestic policy issues that we're going to be seeing in the courts, you know, for years and years to come. And I think we could all name a couple of other similar issues. But when I think about stakeholder implications, you know, I really have been thinking about sort of what are the short-term implications of this decision, and then sort of what does this mean sort of for the longer-term future of the ACA and for all of the people in the healthcare system who interact with the law in one way or another. So in the short term, you know, there's no question from a consumer perspective that this, you know, creates sort of maximum stability, right? There's no questions about the future of coverage that people are enrolled in. Honestly, as we sort of head to the fall, there should be, you know, relatively little confusion about whether the ACA is law or not, right? So from a consumer perspective, there really is sort of a big sigh of relief. And I think that same, you know, feeling transfers over to the provider sector. As we all know, you know, for better or for worse, sort of access to healthcare in this country, you know, really relies in most, if not all cases, on health insurance, right? Especially if it's going to be affordable. And in light of the pandemic and the struggles associated with the provider sector, you know, over the past 18 months or so, you know, I imagine also providers are like, whew, okay, good. You know, we can continue to see the people who are enrolled in coverage under the law. From a plan perspective, you know, same sort of stability theme, of course, and plans who are participating in ACA markets, their bids were already due. And so from that perspective, this saves all of us a whole lot of chaos. And so, there are many circumstances previously that I could think about this time of year where we were like waiting for some kind of policy decision. And, there were questions from plans. Am I going to have to rebid? Should I have submitted 2 bids? Am I going to pull out if a certain decision isn't made? And honestly, that is something that, we are not going to have to experience this year. And I think from a stakeholder perspective, that means that we are likely to see sort of more plans participating in 2022 than we saw in 2021. Similarly, we are more likely to see, the same way that we saw more plans participating in 2020 than we saw in 2019 and the like. So sort of positive momentum there. As we look toward the future, I would ask a couple of questions. One, sort of we are anticipating a more competitive insurance market. What does that mean, right? We are expecting sort of more choices for consumers, which can be a good thing and sometimes could add confusion to the market. So it will be interesting to see how that plays out. Similarly, it will be interesting to see, as we potentially see more entrants from a plan perspective into the exchange market, sort of what do those products look like? What are the strategies of plans? And sort of how does that impact what stakeholders or consumers see as they shop for coverage? And then finally, and I think this hopefully should be a good lead into what Tom is going to talk about, then the question becomes, okay, sort of what are the future policy changes associated with the law? What does the Biden administration try to do via regulation, for example? What does Congress do on issues like a public option, for example? What happens to the temporary assistance approved as part of the American Rescue Plan, right? So those are all questions, and a lot of those changes sort of on whole, are positive for consumers, potentially are very mixed for plans based on sort of the devil is in the details, right? But you kind of follow that through and say, if ACA changes, expansions of the law are going to be made permanent, Congress is likely going to try to pay for them. Sort of who's going to pay for them? Government, consumers, other stakeholders. And so, that sort of next phase of this discussion has many potential stakeholder implications. And then I would just, conclude with sort of where Katie ended up, which is, certainly, there are other cases that we expect to see on the ACA with pretty significant stakeholder implications. I was reading about one the other day related to preventive services, and certainly, that could have really broad implications, not just from the market, but for all the stakeholders I just spoke to. So with that, I will pause and look forward to questions and hand things back to Sarah.
Great, thank you so much, Elizabeth. Yeah, and that was a really great overview. I look forward to getting into more of those implications. And we already have an audience question on the preventive services case, Kelly v. Becerra, so we will also get into that in the Q&A. But first, I am now going to turn it over to Thomas Barker. Thomas, feel free to jump in here. Thanks.
Thanks, Sarah, and thanks everyone for participating today. Good afternoon, or for those of you not on the East Coast, good morning. So I'm going to say a little bit about what I think Congress is likely to do next in light of yesterday's decision. I'll maybe just start off by saying that, as Katie said, you'd like to think that maybe this is the end of the legal challenges for the ACA, but I'm not sure that that's the case. I think that there are, well, someone just mentioned the preventive services case, and there are other cases that are pending. But certainly yesterday's decision was a significant one, and it really does put an end, I think, to the constitutional challenges to the individual mandate that was enacted as part of the APA, as part of the ACA. I mean, it seems to me, I'll just say a little bit about what the options might have been for the court yesterday. They think that the Supreme Court could have decided the case on the issue of severability, whether or not the individual mandate was severable from the remainder of the act, or I guess they could have invalidated the entire ACA, but the decision wound up being a fairly narrow decision on the issue of standing, which, as Katie mentioned, is a constitutional principle. So I just wanted to make that point. Turning now to what I think might happen legislatively, and I'll also say a little bit about what I think might happen in the administration, but just in terms of legislatively, I mean, it's sort of hard for me to see how the Republicans in Congress are going to be able to successfully make any significant changes to the ACA, at least in the near term. The Republicans, even though the Democratic majorities in Congress are very, very, very close, only a couple of seats in the House, a 50-50 tie in the Senate, it seems to me that significant wholesale changes to the ACA by Republicans in Congress, just that doesn't seem to me in the cards anytime soon. I mean, we'll see what happens after the midterm elections next year, but I just don't see any significant changes being successful, again, because of the Democratic majorities in Congress and what would certainly be an uncooperative administration. That being said, I do think that the Republicans in Congress probably will be successful in blocking significant expansions of the ACA. So it's hard for me to see how, for example, a public option can pass. It's hard for me to see how any significant incentives for the states, the handful of states that have not taken up the ACA Medicaid expansion, it's hard for me to see how Congress could take significant steps to increase the incentives, for example, to increase the FMAP for states that have not taken the Medicaid expansion so far. I think lowering the age of eligibility for Medicare, I can't see how that could pass in this closely divided Congress. So I think on the Republican side, the success will come more from blocking significant initiatives rather than repealing, overturning, or making significant changes to the ACA. I will also just point out that the statements that you heard from Republican leadership in the House and Senate yesterday, in my view, sort of seem to acknowledge that point. They didn't, for example, call for repealing and replacing the ACA. That seems to be not as much of a calling card, or not as much of a rallying cry for Republicans in the House as it was before. I will also just point out that I think it's possible that in the next year and a half before the midterm elections, I think it's possible Republicans will try to come up with a larger overall vision of healthcare in the United States. Leader McCarthy's statement yesterday suggested that that may be what they're trying to do. I'll just point out that Republicans historically have not been very successful in articulating a vision, an alternative vision for healthcare. But I think it's possible that they'll try to do that. And I think you could divide that into both small bore initiatives, like, for example, high-risk pools, more FQHCs, other initiatives that Republicans have historically supported. But I also think that I suppose it's possible that there could be a much larger vision that Republicans could come up with. For example, taking the exchange subsidies and the enhanced FMAP for Medicaid and turning those funds over to states to allow states to figure out their own solutions for uninsured individuals. There were significant initiatives in the Trump administration with regard to transparency in healthcare. And I think that might be a part of a Republican larger package for healthcare reform and what I called earlier an alternative vision for healthcare in the United States. So I suppose that that's possible as well. But I just would note that Republicans historically have not been successful in coming up with an alternative vision. We saw that right after President Trump took office, when the repeal and replace the ACA was the rallying cry. The Republicans weren't really able to come up with a significant alternative vision. We'll see what happens over the next couple of years as the midterm elections approach. As I said earlier, I really don't think it's likely that the Republicans in Congress are going to be able to successfully make wholesale revisions to the ACA, given the fact that they don't have a majority in the House and Senate, and that there's an uncooperative administration. The last point I'll make is just what I think the Biden administration is likely to do. Clearly, you saw from President Biden's tweet yesterday that they certainly feel emboldened by yesterday's decision and the fact that it was a 7-2 decision. So as Katie said, it was a significant, resounding decision. And you saw that in President Biden's tweet yesterday afternoon after the decision came down. I think that what the administration is likely to do is just continue what they've been doing, which is supporting the expanded subsidies that were enacted earlier this year in the American Rescue Plan, as President Biden proposed in his budget, making those enhanced subsidies permanent. Proposing other legislative initiatives to expand access to coverage through the exchanges, and also just administrative things that the agency, that HHS can do to make access to exchange plans easier than it had been in the Trump administration. We saw that in the very early days of the Biden administration when they had an open enrollment period for exchange plans, and I think we'll continue to see the Biden administration doing things like that. So again, just to sum up, on the Republican side, in the short term, I really cannot see anything significant happening that would seriously challenge any significant portion of the ACA. On the Democratic side, I think that you'll see the administration continuing to ease implementation and access to coverage via exchange plans, but nothing, at the end of the day, nothing significant happening like lowering the age of eligibility for Medicare, like a public option. I just don't see those types of initiatives happening. And I guess I'll just wrap up by saying we will see over the next year and a half as we approach the midterms whether or not Republicans in Congress come up with an alternative vision for healthcare. That may happen. We're just going to have to wait and see over the next 18 months. So Sarah, with that, I'll turn it back over to you.
Great, thank you so much, Tom. That was a really great overview. And so now I'll invite Katie and Elizabeth back for some Q&A. This was a terrific overview. All right, we're all here. So let me start. I want to kind of group my questions with first, talking a little bit more about the legal aspects here, and then like the policy, and then I got some bigger picture questions here for you guys. So just, one question just on this case itself. We have already a question from the audience, and folks, please do send in your questions. This is about the penalty itself and the unenforceable penalty and implications. And so the person asks, with a penalty less or unenforceable mandate, is there any harm that would confer standing? Does that mean it would be a good strategy to keep the penalty at zero? I remember, Katie, earlier on we talked about, should Congress raise the penalty to $1 to sort of render the case moot? And then a little bit more of a political question, but still kind of strategically, did Republicans shoot themselves in the foot by zeroing out or pushing to zero out the penalty in this case? Maybe Katie, I'll let you take the, so now basically are we at a point where the individual mandate and the enforceability is basically dead for the long haul?
That is my expectation fully. I think, the mandate was the never loved provision, much hated never loved provision of the Affordable Care Act. And so, even, and maybe Tom can speak to this more, even after it was zeroed out in the Tax Cuts and Jobs Act, you had President Trump, saying they eliminated it, they got rid of it, all these things, and it's never been, I think, there's never been momentum, except perhaps in a crisis that could have been set off by the court that didn't come to pass. Any momentum, I think, to increase the penalty. And I actually even worry now, if you were to increase the penalty, and even myself, I've been a little bit flippant in the past, $1 or $5. I think if you were going to actually do that, you'd have to make it a real penalty. I don't have a magic number, but you'd have to increase it much more. if you think about the court now and how much it's changed since 2012, when that NFIB decision with the Chief Justice, construing it as a tax, I don't know if you were to look at this court now, if there would be the same level of support, even for his savings construction as a tax. So the point there, I think it is probably better off to leave the mandate. There's no sort of political support for increasing it. It's clearly not harming anyone. If you look at the markets, which Elizabeth could talk about, everything is more than stable. You're seeing increased enrollment. It doesn't seem to be needed for any reason. And in fact, if you did put the penalty back in, there's a chance that maybe one of these challenges really could come back and you would have a different result from the Supreme Court that you saw in NFIB. So a long way of saying, I think we're probably on solid ground, and I'm not sure anyone is looking at the penalty right now, but I think it's probably staying at zero for the immediate future.
Thank you. But I was interested because I want to stick on this point, because the whole point of the mandate originally, right, was like, is it as an insurance risk mechanism, right? It was to prevent kind of moral hazard, right, of people buying insurance when they got sick, and as a counterbalance to allowing coverage for pre-existing conditions. That seems like it has turned out not to be really the case. But it was making me think yesterday about the Part D enrollment penalties in Medicare Part D, where if somebody enrolls late in the Medicare Part D prescription drug program, there's quite significant penalties if they didn't have comparable coverage. And so what that made me, whether you guys want to comment on Part D or not, what I was curious about is, like, in general, the need to pool risk in insurance and, kind of manage that, like, doesn't go away. So do you have thoughts on, how, like, future health policymakers deal with that challenge? And maybe I'll see if Elizabeth or Thomas wants to jump in on that one.
Yeah, I mean, I'm happy to start. I think I don't want to say the mandate has gotten a bad rap, right? Obviously, there is fraught with political challenge, but from a policy perspective, I think the effectiveness of the mandate was somewhat hamstrung by the sort of design of the mandate, right? And if you make like a pure financial trade-off of the mandate versus purchasing insurance, and we did these analyses sort of in the early days of the ACA, it just wasn't there, right? And so people were sort of financially better off in some cases, not necessarily if they had a major health event, but just from a month-to-month basis, paying the penalty. And so the mandate wasn't really enough to drive behavior. And what we've seen is that what has really been effective at driving behavior, right, is the level of premium subsidization. And, again, sort of very early on, you could see that people sort of on the lower end of the income scale, who were getting those more robust subsidies were absolutely coming to the market. And as sort of the subsidies sort of waned, so did participation, and where people were making this mandate trade-off. Now, I think that at the same time, there definitely was instability sort of in this market in the early days. And you saw some plans say, hey, like, this is not for me, right? Both because certainly the volume was not there that some people had anticipated. And with that lack of volume were certainly some risk issues. Now, I think what you're seeing now is that, things have settled out a little. And, the size of the market is the size of the market, but at the same time, there's a much better understanding of who's going to come and when and why. And now that, industry has a better sense of what that looks like, I think you're going to see even more plans say, hey, let me dip my toe back into the water here.
I'll just add to that, that it's important to get, first of all, I agree with Elizabeth that the penalty was not very high anyway, and so that the mandate wasn't really much of a mandate in the first place. I also think it's worth pointing out where the idea of the mandate came from, which was the Massachusetts healthcare reform law, when Governor Romney got the Massachusetts legislature to enact a healthcare plan, and a mandate was a significant feature of that. And Sarah also pointed out that the concept of penalty for not having coverage, you're right that it appears in Part D, but there's actually also a Part B late enrollment penalty, and that goes back to I think to the 1960s, to the enactment of Medicare. And so the concept of a penalty for not having coverage and enrolling late has been a feature of the American healthcare system for, for 50 years.
Yeah, and Tom, maybe I don't know if you could enlighten us, but have any of those ever been challenged in the past, like those late enrollment penalties in Medicare at least?
Not to my knowledge, no. I mean, I remember during the implementation of Part D in 2005 and 2006, there was a fair amount of political controversy around the late enrollment penalty, but I'm not aware, and there were also judicial challenges to Part D, but not to the late enrollment penalty.
All right, thanks. All right, well, let's keep moving forward because there's a couple questions already about some of the additional cases that might sort of ensue, or at least be brought that are ACA related. So one being on the Kelly v. Becerra case, and Tom, if you could maybe start here. This case suggests that the coverage of preventive services in the ACA should be struck down due to non-delegation and the appointments clause on decisions regarding preventive services. Share a little bit more about what that case is about and what you think the outlook is.
I think I'm familiar with that case because I've been looking at that in the context of vaccines, which obviously are a big issue now because of the FDA EUAs for the COVID vaccines. And I believe, if I'm understanding the non-delegation issue correctly, it's the role that ASA plays in recommending vaccines. And I think that it's not a laughable challenge. At the end of the day, I'd be very, very surprised if the courts were to invalidate the preventive services, the zero deductibles and copay for preventive services. I'd be surprised if that got struck down, but I think it's a fair challenge in the sense that I don't think it's going to get laughed out of court, essentially, is what I'm saying.
Yeah, and Sarah, I can weigh in on that too. So
yeah.
There have been, if you think about all of the litigation to the birth control mandate, the contraceptive mandate, it's all the same statute. So we've seen, but this Kelly case, first it's pending before Judge Reed O'Connor, who is the same judge who was, overturned fully yesterday by the Supreme Court, and he has ruled on so many of the ACA cases. I often devote entire blogs to cases pending before Judge Reed O'Connor. So, it's a case before him, and I'm pointing that out because I do think I think he's going to strike down the preventive services mandate. And then the question will be, what will the Fifth Circuit do? Because that's where that would get appealed to. And if the Fifth Circuit, similar to what we just saw in California versus Texas, what will the Fifth Circuit do? And then will the Supreme Court have to step in? I do think, Tom, I agree with Tom, this is a closer case, and it's a closer case in part because of the Supreme Court's decision on the contraceptive mandate last term in a case called Little Sisters of the Poor versus Pennsylvania, where Justice Thomas wrote that decision. That was over a challenge to Trump-era rules. They upheld the Trump-era rules, but Justice Thomas suggested this idea that the way the preventive services mandate is written, it sort of defers to recommendations made by public health professionals. So it defers to the recommendations of the U.S. Preventive Services Task Force. It defers to HRSA. The idea there that Congress doesn't want to go in and rewrite preventive services guidelines every time there's a change in evidence, so they defer to the experts. This has huge implications, certainly for this very important provision, but across the entire healthcare spectrum. So the idea of non-delegation is that Congress should not be deferring to those other entities. It should be writing these laws and provisions itself. If you think about how much Congress does this in the healthcare context, if you even just think about the No Surprises Act, the surprise medical bill legislation that passed in December, and how much is deferred to the federal government or even preventive services to some outside entities, it has huge implications that could really rock the healthcare system. And so even non-delegation doctrine, it was cited in striking down Oklahoma Medicaid managed care. We're seeing it across the board. And last thing I'll say on this, clearly I get all amped up about non-delegation doctrine, but I do think folks on the Hill in particular should be thinking about this. And there are multiple challenges on this front. It's not just this Kelly case. There's another separate case in Texas before a district court there. And a lot of it's being driven by the PrEP, certainly the birth control mandate part of preventive services, but there was a recommendation by the Preventive Services Task Force to cover pre-exposure prophylaxis, which is an HIV prevention medication. And you have folks making, you know, sort of religious objection claims to the coverage of PrEP and contraceptives, and even HIV testing and STD testing, and that's why they're challenging the preventive services mandate as unconstitutional under this doctrine. So there's a lot to unpack there. I think it's really, really important. But if non-delegation doctrine really does take off in the courts, I think the healthcare world is in for a world of hurt, to be quite honest.
That's interesting because, yeah, Elizabeth, go ahead. I want to hear your thoughts on that.
No, I was just going to say, I mean, if Congress can't punt the hard decisions to somebody else, like when are they ever going to be able to agree on anything, right? I mean, if you take that off the table, I would just also say, you know, the preventive services case in particular, right? If you think about it sort of broadly, you know, this is a case that really potentially, you know, expands this debate sort of to the traditional employer-sponsored insurance market, which is sort of an interesting and new dynamic and raises all kinds of questions. I mean, there's all kinds of investment that's going on in prevention, whether that be in sort of innovation related to prevention, as you talked about, PrEP, screening and the like, right? But then there's also this question where if that went away, you know, sort of how does the market react, right? Like, does an employer suddenly want to say, oh, wait, you know, no, I'm not covering your colonoscopy with no cost sharing or your vaccine? So there is just some real complexity here. And when you talk about provisions of the ACA that had sort of the widest reach, this is really one of them. So I expect that there's going to be a broader group of stakeholders following this case than maybe even, you know, some of these prior cases where, yeah, there was like a lot of noise about the whole ACA going away. I don't think, you know, many people felt like that was the most likely outcome. But on this one, you know, there are just really potential wide-ranging implications that bring sort of new groups of stakeholders into the debate.
That's helpful. And I mean, just to be clear, it means that the alternative is if Congress can't, like you said, sort of delegate to a different body of, you know, appropriate experts, if you will. I mean, what happens? I mean, they have to then get even more in the weeds. Or Tom, you know, you were general counsel at HHS. I mean, how does that even then work in like a rulemaking process? Or what does that imply for then a future role for like a CMS or a HHS?
I mean, it really would. I don't want to maybe paralyze is too strong of a word, but it would really slow down the ability of the agency to undertake its most basic responsibilities. I'll just give an example. The Supreme Court's Alina decision from 2 years ago, which was a decision that really forced the agency to go through notice and comment rulemaking for a lot of decisions that it did not previously have to go through notice and comment rulemaking for. And that is really, this is just in the Medicare program, but it has really made it difficult for CMS to undertake its most basic responsibilities. And so a literal expansion of the non-delegation doctrine to make these most basic decisions that actually have to be made by Congress would really just slow everything down, both what the agency does and how the agency implements policies.
Great, thank you. I just want to ask one more about the risk corridor in terms of sort of additional cases that might come up, or actually rather, I'm sorry, I meant the, Katie, you had brought up the cost sharing reduction payment lawsuit. I just want to discern a little bit because it seems like that has a little bit of a different flavor to it in terms of like who the plaintiffs are, what the concerns are. Can you maybe elaborate a little bit on that and sort of share how you see that playing out?
Sure, it is related to a Supreme Court decision on risk corridors, which is why that's on your brain, Sarah, that was decided last term. And so the idea here, I mean, some of this relates to, sort of so-called ACA sabotage, both the risk corridors cases and the CSR cases. Cost sharing reductions are for lower income people. They're supposed to be paid directly from the federal government to the insurance companies, and then insurance companies offer sort of plans with lower out-of-pocket costs for those who qualify. President Trump there have been lawsuits about this going back millennia, including a lawsuit initially filed by then Speaker John Boehner, so I will spare you that. But President Trump, following the failed kind of ACA repeal efforts in 2017, directed HHS to shut off those payments to insurance companies. So insurance companies are still required to offer those plans with lower out-of-pocket costs, but they weren't getting any money. In response, a lot of them did what we call silver loading. They kind of looked at the premium tax credits, the other ACA subsidy, and ramped those up to cover whatever they were going to lose on the cost sharing reductions. And so that's what makes it a little bit different from the risk corridors case. In that case, the Supreme Court, and that was an 8-1 decision, if I'm remembering correctly, said, yeah, insurance companies are owed this money, even though there was no appropriation, they're still paid, and they were awarded a little bit over $12 billion. Insurance companies have cited that decision to say, we're also owed these unpaid cost sharing reductions. The statutes do look very similar. And so they've gone to sue. The question here, and what the appellate court said, was, yes, you are owed those unpaid dollars, but we recognize that you also got some offset when you increased premiums and got higher premium tax credits. So we'll make you whole, but we're not going to give you sort of a windfall or a double recovery. You don't get to raise premiums, capture more subsidies here, and then go to court and sue for everything you're owed. And so the insurance companies are the ones who have appealed. They have to the Supreme Court, and Paul Clement, who is a Supreme Court advocate who actually won the risk corridors case, is on all those briefs. They're really framing it as kind of a statutory interpretation question. We'll see. It takes the votes of 4 justices on the Supreme Court to hear a case, and like I said, they were supposed to have considered it yesterday at their conference. Maybe we'll hear on Monday. Maybe we'll hear sooner or later if they're going to take it, and if they take it, it would be for the next term. So a long way of saying sort of a wonky dollars and cents issue that's very important to insurance companies. But I know Congress is also looking at cost sharing reductions potentially as a pay for, or other things that I could let Tom and Elizabeth speak to. But I think folks do care about what happens in this case because it will affect maybe some proposed legislation.
Yeah, thanks. And Elizabeth, we had an audience question around the risk corridors particularly, but I think it's a little broader than that, which is just, is there concern in Congress? I think we can probably answer that question, but on both sides of the aisle, perhaps about the profitability of insurers on the exchanges or, narrow networks, how does that all kind of tie in?
Yeah, I mean, it's a good question. I would say that what we hear sort of from consumers historically was really that they wanted lower monthly premiums, right? That the biggest decision-making factor, sometimes probably not in the consumer's best interest in terms of overall cost, was lower premiums, right? And so things like, narrower networks or higher deductibles are really about bringing a product to market that is in many ways giving the consumer what they're asking for, which is lower premiums. Now, I think actually in advance of the 2020 election, you saw a lot less focus on concern over monthly costs and much more focus on sort of out-of-pocket costs that certainly led into the discussion about surprise billing, but also lead to this question of cost sharing and the deductibles and the like. And I do think that's a place where Congress has zeroed in. It's certainly something that comes up a lot in the context of drug prices, right? Is sort of what is the consumer paying out of pocket? Now, on the profitability side, I would also say, insurers have a pretty good sort of answer to that question, which is, we have MLR, right? And there are a lot of other sort of industries across healthcare that don't. And so I think you will hear an insurance company say, like, look, we have MLR, we're complying. If we're not complying, we're refunding. And certainly, during the pandemic, there has been some attention on that. And I think, the insurance industry has also recognized, look, we're in a unique situation and we're going to, do what we need to do sort of under the law here.
Yeah, thanks. And of course, for those newer to the issues, MLR is, of course, the medical loss ratio that requires insurance companies pay rebates back to consumers or to their, an employer health plan if they exceed. Elizabeth, you're going to say this better than I have, like too many cicadas around in my head, but 85% of their revenue has been spent on actual medical care, or 80%, depending. Did I get that right?
I mean, it's been one of the backstops, right, of the ACA is that insurance companies have to spend a certain amount of what they take in premiums out on medical care. And it's something that we see across markets, including in Medicare Advantage.
Great. All right, so we have about 10 minutes left, and we already have some really fantastic questions. We've been getting some fantastic questions from the audience. So I want to turn a little bit more now to what's next in terms of just, coverage in general. I want to ask first, Tom, about, as you look to perhaps a role for the states, it was interesting, Katie, when you were talking initially about the court not finding that the states would be harmed, but that kind of their argument was like, well, we're going to be harmed because people are going to take up coverage in some form or fashion. But Tom, you also then mentioned like maybe there's some solution on the horizon where more control gets sort of put to the states, and certainly that's been a hallmark of American health policy, right? Is the states really making a lot of decisions. I mean, what role do you see for the states? I mean, absent some sort of big, grand, new vision for coverage, like what role do you see for the states kind of in the short to medium term?
I think in the short to medium term, anything that happens at the state level, it's probably going to happen through Medicaid, through the enhanced use of Medicaid 1115 waivers, such as what Texas was trying to do, although the Texas waiver the renewal of the Texas waiver was blocked by the Biden administration. But I do think in general, you'll see Republican-led states, especially using Medicaid waivers perhaps a little bit more. Also, maybe reforms to the small group and individual market at the state level. But when I mentioned states, I was also thinking of a much bigger concept where, and this is something that goes back at least to the Bush administration that we were kicking around in the Bush administration, which is taking the subsidies that are in the American healthcare system right now, whether it's Medicaid DISH, now the enhanced FMAP for ACA expansion, the exchange subsidies, taking those extra payments in the healthcare system and turning them over to states and just essentially making a grant to the states and saying to the states, you figure out how to deal with the uninsured population within your borders, and because we, the federal government, think that you are in a better position to make those decisions. Doing that would be extremely controversial. I'm not seeing a pathway for that getting enacted anytime soon. So that's certainly a long-term solution. But I think that if you're to think about a Republican vision for healthcare reform, it would look more like that. Again, to sum up, taking the existing subsidies in the American healthcare system and turning them over to the states in the form of a grant.
Yeah, and one quick follow-up, because someone did write in from the audience, and I think they are a state policymaker, asking, many of us at the state level are interested in pursuing state-level ACA coverage expansions. They cite Section 1332. Yeah, and so do you think, what future do you see for 1332? Do you think the court decision has any impact on it? And what do you think, states are going to do with that provision moving forward?
I don't think that yesterday's decision necessarily affects Section 1332 or, for that matter, 1115 waivers, but I do think that you are going to see renewed interest by states in taking advantage of the flexibilities that they got under Section 1332 of the ACA or 1115 waivers.
Yeah, thank you. All right, I want to ask Elizabeth and Katie to quickly weigh in on just the state insurance market, since Elizabeth, you mentioned foreseeing more competition, more plans. I mean, certainly, choice has been, again, one of the the stated goals amongst some parties. What do you think states and state regulators are going to do with that to either enhance choice and competition on the exchanges or more broadly in their marketplaces? And then Katie, I'd ask for your thoughts on the same question before we wrap with a couple of closing questions.
Yeah, I mean, I think, it will be interesting to see sort of as we head into 2022, sort of where competition picks up, sort of where different insurers place their ultimate bets and sort of how that impacts the market in any particular state, right? So I think what we've learned with this law and these markets in particular is that the variation sort of state to state, county to county can be significant. I think to the question that you had earlier, I think there is some expectation, I'll be interested in Katie's thoughts here, that we may get some additional guidance from the administration as it relates to 1332 waivers, and to the degree, to Tom's point, that sort of Congress is not an effective vehicle for, sort of improvements or enhancements to the Affordable Care Act, that perhaps this administration could sort of lean into that 1332 authority to try to give, some additional flexibility to states who want to take this on. And so I'm interested, Katie, if you're thinking along the same lines.
Yeah, I think that's right. And I think I guess I'm a little bit hesitant. I think thinking through who is at the White House and at HHS, there are a lot of folks who were around during the Obama administration, and even the 1332 guidance from the Obama administration was not known for its flexibility. I think there were blue states and red states who both sort of chafed at that guidance. So I'll be interested to see if they are proactive about, what their interpretation of that is going to be or not. I think they do have to do some cleanup of some of the things the Trump administration did, but the question is what they say proactively or if they go further. Even if they don't say something, I have been surprised by how much state activity there has been. So even in the past 2 weeks, seeing, state, Nevada, Colorado, Washington, states are looking at public options. They're sort of moving ahead, and at least the Colorado and Nevada proposals include a 1332 waiver. So I think the Biden administration is going to be pushed one way or another in terms of what it's going to do for some of these sort of broader coverage options by at least some of the states. So that's something I want to keep an eye out for too. One question I was thinking about, Tom, as you were talking, is if, there used to be the Alexander Murray proposal in Congress after the failed ACA repeal efforts in 2017, and that included, some negotiated changes to 1332. I know Senator Alexander is no longer there, but I do wonder if we'll see some of that maybe creative bipartisan approach to, maybe we can move on and do some bipartisan things on the ACA. Maybe I sound too naive, but I was like, oh, that was a thing before. Maybe there's some world, but I don't know if you have a take on that.
Well, Katie, you led right in, and sorry, Tom, to jump in, but this is a great wrap-up question, because we've had 2 or 3 from the audience here about just at the 30,000-foot level. What do all these lawsuits mean for legislation that pass on purely, partisan lines? Does this really fundamentally highlight the importance of bipartisan bills going forward, of bipartisanship? I'd love to have a whole nother webinar on what those bipartisan approaches potentially could look like. We seem like we're maybe in the trickle down of not too many more like fundamentally challenging lawsuits on this, but at some point, right, healthcare still isn't as affordable or equitable as it could be. So maybe, Katie, I know you commented on Alexander Murray. We just have a couple minutes left, so I'll kick it to Tom to see if you have thoughts on that question, and then we'll end with Elizabeth.
I mean, my thoughts are, as much as I would love for that to be the case, for there to be, as Katie mentioned, bipartisan healthcare initiative. When I worked on the Hill back in the 1980s, and there were plenty of bipartisan healthcare initiatives back in the 1980s, I'm just skeptical that it can happen, at least in a Congress that's this closely divided, which seems counterintuitive. You would think that with a Congress this closely divided, there would be a greater incentive for bipartisanship, but I just am not. Unfortunately, I'm just not seeing that happen.
Elizabeth, before you answer that question, I want you to kind of twist it a little bit and talk about what would a more bipartisan approach mean for the industry stakeholders that you work with, and then for consumers.
Yeah, sure. I mean, bipartisanship creates some stability, right? Which stakeholders of all kinds like, right? I think from a business perspective, being able to plan and sort of anticipate the policy and regulatory environment is important. If you are a company that is constantly fearing, okay, I've invested in these programs under these rules, and there is this constant threat that tomorrow those rules could look wildly different. It doesn't give you a ton of incentive to make, to go all in, because, well, if tomorrow it's going to be different, then I've just spent, all of these resources to pursue something under one set of standards. So, of course, I think it would be beneficial for consumers to know what's coming, but it would also be beneficial for companies that are thinking about growing and being strategic and serving the patients that all of us want them to serve, if there was some more predictability of sort of what the future might look like.
Great.
Yeah.
Well,
At the same time, I would say that some of the dysfunction creates some of that stability by default, right?
Yeah.
And I think you have more and more companies being like, well, I don't really actually think they're going to act to do anything on Capitol Hill, so I'm just going to ignore it all.
Right. But gridlock and strategy are two different things. So, right. So, yeah. Well, thank you. Thank you, everybody. Thank you for joining us today. Thanks to our audience. Again, check out allhealthpolicy.org for a recording of this webinar later in the day. Elizabeth Carpenter, Katie Keith, Thomas Barker, thank you for joining us. And let's all get together soon and talk about something besides standing. How about that? All right. Thank you, guys. Have a wonderful, wonderful weekend. Bye.
Take care. Bye.
Take care. Bye-bye.